here to give you a very brief overview of what happens when the train goes off the tracks, which I hope does not happen to anyone in this room. But unfortunately, as the previous speakers have noted, this does happen. Unfortunately, seniors do get exploited financially. And fortunately, the courts do see these disputes often, and the courts are, frankly, ready to step into the breach and help folks. And we've had a number of these cases over the years. So I'm just going to give you some examples of what we've done. Obviously, we value client confidentiality, as you would expect and as our clients in the past expect. So when I give you examples of these case studies, which are really just thumbnail sketches of what happened, I've sanitized the details so you won't know who I'm talking about. So let me give you case number one. We receive a call from an estate planning attorney. Now, this estate planning attorney doesn't practice in the area of litigation, but this attorney comes to us, as sometimes is the case, with a client where there are red flags of financial exploitation. We have a disabled woman who has two siblings. One of those siblings has told the disabled sibling, the eventual client, that they really need to sign this power of attorney so their assets can be transferred, because if they don't do that, the state of Connecticut, which has been providing some care to the disabled person, is going to take the house. They're going to take all these other financial assets, bank accounts, insurance products. They're going to take them. So you really have to sign this power of attorney. So our client, the disabled man, or did I say woman? Trusting the sibling, signs the document. Well, that document is then used as a tool for abuse. And that power of attorney becomes a weapon. A home is transferred. Bank accounts are transferred. A trust is created that basically ties up these assets so only the bad actor can touch them, and which precludes the true owner of these assets from having an estate plan that that disabled person wanted. So what did we do? We came in and frankly we filed a lawsuit, because once a person has decided to take steps like that, you have to go to court. And that's what I'm saying here, is that when events like this transpire, this is when you go to court. This is one of those rare examples where you're going to interact with the court system. And we sued and we asserted numerous causes of action, which are terms of art. We sued for unjust enrichment, and we sued for invalidation of these transfers. We basically want to get these assets back. And what we did in this case and what we have done in other cases is sue for statutory theft. There's a statute in Connecticut. It's not a criminal statute, it's a civil statute. But what it says is if someone essentially commits larceny against you, they steal your property and they do it with intent, that you can recover treble damages. And what we have found in these cases is that's a hammer. And in this case and in other cases, in a very short time frame, the assets were returned. And some of our attorney's fees were paid, because we've gone to court. And as Justice Brandeis of the U.S. Supreme Court stated, sunlight is the best antiseptic. So that's what happens. You go to court, and the bad actors know the jig is up. So that's the first example. The second example is similar. And why I'm mentioning this example is because it highlights some of the red flags that family members should be aware of. Dad suffers from dementia, but not to the point where he can't have a conversation. He's competent, but he suffers from dementia. Well, the bad son, I'll call it the bad son, he decides he'd like to take Dad on a day trip. So they go on a day trip, and they go to the coastline. And, turns out that there's a trip to a bank that wasn't disclosed. And what are they doing at the bank? Well, a power of attorney is going to be executed. And that's what happens. A power of attorney is executed. And once again, it becomes a weapon. And it's a secret. The bad actor says, we really don't need to mention this to anybody. It's a secret. What happens is we get a call from the good child who happened to see that a bank account had been retitled because he was over Dad's house and he saw some paperwork. Again, we come in and we record. One of the things I didn't mention in the last example is that with real estate, one of the things that you need to do right away when title has been transferred improperly, essentially stolen, is to record a notice of lis pendens on the land records. Because what you're worried about in these scenarios is that the bad actor, who now has title, sometimes, will encumber the asset, liquidate it in part, or sell it to get money, and then you'll end up chasing money. So what you have to do right away is file a notice of lis pendens on the land records, which gives the world at large legal and constructive notice that there is a dispute about title to this property. So that's one of the important things that you need a lawyer to do right away. So we sprang into action here, recorded the notice of lis pendens, sued right away, and what we did in this case is we asked the court for an injunction right out of the gate. Anybody in here familiar with the term injunction? Okay. What you're asking a court to do is order that someone can't do something. In financial elder abuse cases, this is something that we ask for frequently because the bad actor will be in possession of a weapon, not a gun or a knife, but a document that they can take around and do bad things with. So in this case, we asked for an ex parte order from the court, where without a hearing, we ask a judge to look at paperwork where we explain this story of what has happened. And we want an order right away, before there's a hearing, an order from the judge precluding the bad actor from doing any more harm until there can be a hearing. In this case, we were lucky enough to get it, and we served it right away that night. The bad actor hired a lawyer, and the case was resolved in a matter of days. What I'm getting at with these two examples is that quick action by an attorney is key in these scenarios. Because if someone is desperate and depraved enough to take property from a loved one, you have to act quickly because that money may go. There is a opioid epidemic in this country, as everybody here is probably aware. Money is stolen frequently by people who have drug problems, also gambling problems. Without taking quick action, that money can be gone forever. So taking quick action, injunctive action, getting an order from a court that's punishable by contempt if a person acts in contravention of that order is key. The last example I'll give is different in nature. The first two cases I talked about were the equivalent of a daytime robbery of a liquor store, okay, where it's obvious what happened. An elderly person was taken advantage of. Their property was stolen. There is another type of financial elder abuse that is more sophisticated and, frankly, hard to figure out. And we had a case like this where the red flags are harder to see. What do I mean by that? Sometimes this can be the case when there are two or more children, and it just so happens that one of the children, for a long time often, has had a very, well, they've had a lot of contact with the parent, mom or dad. It's not that the other children don't have a loving relationship with the parent, it's just that there happens to be one child, perhaps who lives geographically close, that has the stronger relationship. Sometimes that person is savvy, and they take steps over time and in a subtle manner to have assets retitled, investment accounts, bank accounts, real estate. And there's nothing inherently wrong with that. But we've had cases where over time that's done. And what happens is mom or dad doesn't understand the significance of making an asset joint. Or stated in a better way, they don't understand that making an asset joint entitles the other joint asset holder to take advantage of that situation if they're a bad actor. What happened in our case was that a father, he was a widower, had an investment account with lots of money in it. And he had made it joint with his son, with one of his two sons. But in his mind, making it joint didn't mean that half of it, or 40% or 60%, went to his son that he made joint. It meant to him that his son could help him manage that account, could act in his best interest. And yes, when father died, whatever was in that account would go to that son. Well, that's all well and good if the son acts that way. But what happens when the son decides that's half of his money now? And that's what happened in our case. All of a sudden, there was a triggering event, a family dispute, where the son now tried to undermine the ownership of that rather large account by the father, and in fact undid a rather significant stock transaction. So there can be subtle and what appears to be non-threatening retitling of assets over time. And it can be dangerous if it can be dangerous if the understandings of the parties are not clear. Sometimes you just don't know if a family member is going to try to take advantage of you later on. And it's sad we even have to have this discussion, frankly. But I wanted to give a more nuanced example of financial abuse, because I would be oversimplifying it if I just gave the examples of the noon liquor store robbery. In closing, the one thing that I would want you to remember from my talk tonight is that quick action is essential in these matters. It really is an emergency when it becomes clear that money has gone missing. So ask questions of loved ones. We've had situations where looking at a senior's checkbook register has shown that something has gone wrong. Ask questions, and if you feel that something's wrong, consult a lawyer immediately, because absent prompt legal action, assets can go missing. And people think that a judgment against a person is cash. It's not. And we have judgments sometimes that we just can't collect. You don't want that to happen. You want to preserve the asset.